Good morning. Good morning.
Please be seated. This court's in session.
Good morning, sir. It's Flaherty, initial J. I'm here on the matter of Mr. Katsikaris, who appears before the court, and at this stage, I believe, represents himself. There are some preliminary matters that I wanted to address with you, sir, before any arraignment, because I think at this stage, it is my understanding Mr. Katsikaris is representing himself, so we should just confirm that. Is that fair?
Yes, I am. I've been representing myself for the last year trying to get disclosure, Mr. Flaherty.
Okay, so that's the first issue. Then the next issue is the one that was just raised by Mr. Katsikaris. I'm grateful to him for raising that. The process that led to today's trial date, as Your Honor is quite familiar, involves open court JPTs in front of brother or sister judges here at Old City Hall and 112 Court to be able to first of all, secure an understanding about whether an accused person wants to be represented by counsel or not, and you've heard that that process has been exhausted and led to Mr. Katsikaris wanting to represent himself. Then there was a series of requests by Mr. Katsikaris to come into possession of an item of disclosure in this case, and that item of disclosure is an audio statement, brief, about half an hour in length, from the object of the threat, Mr. Paul Martin. And Paul Martin's audio tape is disclosure in this case, but the Crown took the position, which was confirmed by the JPT judge, that the Crown was acting appropriately by being able to suggest to Mr. Katsikaris that he make an appointment, come in, view it as many times as he wished, on as many occasions, and in fact, we had the matter come back in front of 112 Court, in front of Justice Clark and other justices, to be able to ensure that Mr. Katsikaris' mind had not changed about wanting to make the appointments, many if he wished, to be able to view and review that statement. But I believe Mr. Katsikaris, and I don't want to put any words in his mouth because he's very capable in expressing himself, desired to have in his own personal possession these items. And the reason why, the item I should say, and the reason why the Crown could not give him the item, as Your Honor will see as we get into the evidence in this case, is there is evidence of the use of images of Paul Martin and associations to various personal details about Paul Martin that are part of the objective background to the threat. And so the Crown did not wish an opportunity for Mr. Katsikaris to be able to edit, misuse, take any of these items and use them to participate potentially in criminal harassment and or in any other form of augmenting the severity of the offense as it was. And so, as Your Honor is aware, with a lot of cases, especially sex assaults, the Crown takes the view that the actual disc need not be in the possession of an accused, and this practice has been accepted in our courthouse. It's been accepted because there's exhaustive efforts made to be able to put the accused in position of the information and the video or audio tapes that allow the accused to know the case that the Crown proposes to present. I had indicated throughout the process that it was not actually my intention to call Paul Martin as a witness, but a statement was taken by the police with respect to Paul Martin and his views about the severity of the threat, which is potentially relevant, but I had tried to see a way to not augment the level I'll just put it this way. It was the Crown's wish to simplify the process, and Your Honor will see that wish is going to be preserved by the Crown throughout my positions that I take on this case. So what I wanted to propose, Your Honor, before any arraignment is that I be given an opportunity to play the statement of Paul Martin to Mr. Katsikaris if he wanted it replayed, if he wanted a chance to be able to contemplate about it, he could take it, but I need to be able to advance this case because, as I understand it, even Mr. Katsikaris wants the case to proceed. Now, there's another little gem that I want to tell Your Honor about is that there is a series of videos that were put on the internet that are attributable to Mr. Katsikaris. Some because Mr. Katsikaris appears in them, narrating them. And so these are not videos unknown to Mr. Katsikaris. That's the belief of the Crown. Because the Crown wished to be able to tender 4 of those videos, I included a videotape compilation as disclosure, and I had it made available for Mr. Katsikaris' pickup. The items were not picked up before Christmas. Then I had one of the staffers here make a call to Mr. Katsikaris' sheriff, who is present in court, to be able to ensure that Mr. Katsikaris was aware of his ability to pick this up. Today, when I appear, it has not been picked up. And so I would also be open to being able to play those videos. And so there would be a slight delay to the commencement of this trial. But it is a short trial when we boil it down, it's a short trial.
I think what's going to happen, this case is going to go on into the spring when I'm gone. Like it's just tough.
Well, it may or may not, sir. It may or may not.
It's going to go on and on and on. I don't know why I was assigned this case, because the trial court knows my situation. I think we should maybe have another pre-trial, doing what you said, showing the stuff, and then we'll put it over for a trial before somebody else.
So the difficulty is that I think Mr. Katsikaris wants his trial. And so,
well, he can't have it. He can't have it all ways. He can't say, I demand this, that, and the other thing, and then not to proceed to trial.
All right. Well, I wonder if we could do this, sir. I wonder if we could just find out from Mr. Katsikaris whether he'd be prepared to see this disclosure. That might be a first step.
Okay, I'm going to, unless you want me to act as a pretrial judge right now.
Right. I don't want you to act as a pretrial judge,
but
I want to give him the opportunity to see it.
Okay, and we'll see. And I'm going to speak to the trial court.
All right. Thank you.
All right. Adjourn for vote 10.
Mr. Flaherty, based on what you told me before we recess, what's the next?
So what I can advise you, Your Honor, is I did offer Mr. Katsikaris a chance to hear the audio statement of Paul Martin, and then also to see any video images that the Crown proposes to rely upon today for a number. And I was told by Mr. Katsikaris that he did not wish that. But he said a number of other things which have led to the Crown having the belief that there are issues with respect to whether Mr. Katsikaris is fit under the code. And by that I mean not that he doesn't understand the personages of Your Honor's role and who you are, or what the Crown's role is and who I am. But it would be under the area of fitness where the question is whether the person can actually give instructions to counsel based upon whatever underlying mental health condition is informing some, in this case, conspiratorial thoughts, and so whether that would render him incapable of being able to give those instructions. And so I think it has arisen as an issue, sir, and because I would still want to keep Your Honor as a potential trial judge, I don't even have to bring this application for a fitness assessment in front of Your Honor. I can actually just have it go to 102 and I can make the application there. That way we could still preserve Your Honor as a trial judge. The Crown could still be able to be in the position to say the Crown's ready to proceed today. And
all right, well, we'll take one step at a time. So now, are you willing to go down to 102?
No, sir. Mr. Flaherty does not have any evidence that I have a mental health condition whatsoever. He's lying his head off. So you have any evidence of that right now?
I was prepared to call Officer Kilby to testify
He's not a doctor.
to what Mr. Katsikaris indicated to both Detective Kilby and I in the process of wanting to have him view his disclosure, because there have been so many efforts made to try and have Mr. Katsikaris view his disclosure, and they've been unsuccessful, unfortunately. And so I think it might just be simplest, sir, if we traverse the matter to 102 and I make my application for a fitness assessment in 102 court.
Well, I can't force him to go there if he doesn't want to go there.
You can traverse the matter there, or I can call evidence, but I am wanting to make sure that Your Honor can still remain the trial judge.
Well, I will for the moment, but I've spoken to the trial coordinator and there might be other things.
All right. So is it, Your Honor, are you content that I have the matter traversed to 102 to have the Crown application for an assessment for
Do you need to put anything on record? Would that be wise?
Well, I would want to call Detective Kilby to testify to what Mr. Katsikaris said today.
Well, why don't we do that? If that's...
Are you prepared to entertain the Crown's application here then?
Well, for the purposes of sending it to 102, I am.
All right. Okay, so the Crown is seeking a Form 48, which is the ability to have an assessment of Mr. Katsikaris' fitness to stand trial assessed based upon the low threshold that the Crown has to satisfy. And to that end, I might just invite Detective Kilby to come forward and be sworn and provide evidence in support of that Crown application under 672. And just to use layman's language so that it's completely understood to Mr. Katsikaris, the Crown is of the belief that there would be a difficulty in providing instructions to counsel, one of the bases of being fit and able to participate meaningfully in a trial. And so the Crown is seeking an opportunity for a doctor in 102 court between the hours of 1 p.m. and 2 p.m. today, a physician from CAMH, a psychiatrist, to be able to talk to you about fitness and then come to a conclusion about whether you're fit or not. You may be fit, you may not be fit, but the Crown believes there are grounds for this assessment to inquire into whether you are fit.
Your Honor, I've been coming to court twice a month for a whole year, driving 3 hours each way. I'm a professional pilot by trade. This is ridiculous. The Crown has no grounds at all, no doctor assessment. I refuse to see a doctor because the whole reason why I'm here is because I was experiencing nightmares. Nightmares does not mean I'm not fit. And according to the Constitution of Canada, I have the right to a fair trial, and the Crown has been trying to derail this case, and when he couldn't do it, he tried to kill me, along with police, on July 28th with a SWAT team from Aurelia, Ontario, blew up my door with a bloody explosive, threatened to bite me with a dog, had a helicopter flying over, and my brother is right here, was taken off the property without a warrant, and they tried to kill me. This is conspiracy to commit murder. He's trying to whitewash this case. I want this to go to trial in front of Canadian citizens, and I am fit. I know the law. Stitchcom 1991 says I have the right to full disclosure no matter what. It's my property. Even though the Crown's case is hurt or destroyed by this matter, it doesn't matter. I still get it. And I will not go see a psychiatrist in 102. And since we're talking about 102, on April 11th, I did have a court order from a Red Sass judge to give me disclosure, and Mr. Flaherty pulled it from the file. He's obstructing justice and conspiracy to commit murder, along with that guy right up there, and I still don't know his name yet. He's involved in this, coming in my house without a warrant. We got videos on YouTube. I think you might want to take a look at it before making any decisions. These guys even admitted they didn't have a warrant when they were in my house. So, they did try to kill me once, 3 friggin' times in the last year. And now they're trying to whitewash this and trying to go to a mental health court where I already been without a psychiatric report and a judge's order already saying I get full disclosure. Everything. So, what's going to happen here? I want justice. I want a fair trial. I want to represent myself. And the other lawyer, Michael McKean, wanted me to plead guilty in February 11th. And he didn't show up. And this cop was standing in representing me in mental health court. And the judge is on the record saying this is a guilty plea. This man in front of us right now is obstructing justice. He's a crooked cop. And I want to question him in front of a jury. And he's going to jail for conspiracy.
In front of a jury?